Good afternoon, everyone, and good morning for those who are not on the East Coast. I am Trent Taylor. I am in the Richmond office of McGuireWoods, and we are very excited today to have you join us for our CBD webinar. Now, before we begin, I'm going to be like those flight attendants on flights who make sure you're actually supposed to be on this flight instead of some other flight. First of all, this is not the webinar about how to score the best weed. That may or may not be a future webinar that's put on by someone, but that is certainly not today's subject. And so I'm sorry to disappoint some of you, but we will be discussing CBD and class actions. And we have a, sorry, I'm moving to the next slide. Give me just one second. All right. So this is our who will be presenting today. We have a fantastic group spanning the nation. We have two here in Richmond, myself and Jenny Price. We have Kate Hardy in Charlotte. We have Royce DeBuner in Chicago. And then we have Bethany Lukic in LA. And Kate and Royce are really experts on regulatory and especially CBD. They put on an event about CBD a couple of months ago in Dallas that was very successful. And Bethany and Jenny are world-class litigators who have a lot of experience handling different types of class actions related to a number of products, including food products. So they're going to be able to give you the litigation perspective. I am also a litigator, and I will chime in and present on parts of this as well. All right, so before we actually get into the content, one quick plug. Here at McGuireWoods, we try very hard to keep our finger on the pulse of what is going on out there in the regulatory and litigation environments related to product and food and beverage labeling. And one of the things that we do is we have a monthly newsletter that we do on labeling trends that Royce contributes to, as well as one of our fantastic associates, Ben Abel, also puts together. And then we also have, and this is new, a labeling and regulatory emergency hotline and dedicated email address, so that if any of our clients or our other friends have particular questions on things and they need a quick answer, this is a way that they can have a quick answer. So just keep that in mind for the future in case you ever need it. All right, so let's get into what we're going to be talking about today. Here's sort of our roadmap, if you will. I'm going to give a quick introduction about CBD, and then Kate and Royce are going to talk about CBD basics and recent regulatory actions related to CBD. Then Jenny, Bethany, and myself will be talking about the various class actions that have been filed to date. Bethany's going to be talking about illegal to sell, and then Jenny and I will be handling too little CBD, too much CBD, and securities. And then at the very end, we're going to have some predictions and some tips about maybe how to avoid some of this litigation that we're all going to contribute to. So let's get started with a brief introduction to CBD. So first of all, why is CBD so hot? And I think it really comes down to everyone loves this product and anything related to CBD, and sales are just soaring. You can see on this slide that sales of CBD products are projected to hit almost $24 billion in the United States alone by 2023, and the year-over-year sales growth in 2019 was estimated to be over 700%. So really just astronomical growth in sales. And there really is a real sense that adding CBD to pretty much any product will supercharge sales of that product. And I think maybe a lot of us may be familiar with, the little bottles of CBD oil, and I have one actually here in Richmond, and where we are presenting, that was given to me. And I know Royce also has a number of these kinds of products. But one of the things that I think is particularly interesting is how ubiquitous CBD is right now. It's not just in the CBD oil. And you see from this slide, I mean, you literally can't turn around without seeing something else that is CBD infused. And one of the reasons why I think we're seeing such growth with CBD in particular is that you see CBD products at a number of various retailers, and it's very different than marijuana edibles that you would see with maybe food trucks in big cities, but you wouldn't see at major retailers. But we're seeing CBD products being sold by big grocery stores, like some of the Kroger stores, CVS, really big retailers that you're seeing pretty much all over the country. Now, I have a slide here with some of the products that we're seeing out there. And on this slide alone, it may be a little bit difficult to view, but you have CBD potato chips, CBD gummies, and of course that's a big one. CBD gummies, a lot of folks have purchased those. There's CBD pet treats, which I think is interesting. There was a CBD burger at Carl's Jr. At one point. Now, I think it was a limited edition and it didn't go for very long. And then there's CBD toothpaste, which is a real thing, apparently. There's also CBD-Infused Toothpicks, which is interesting. But even setting aside the CBD part of this, I don't know if you can see it on the screen, but check out the size of those toothpicks. I mean, those are massive. You also have CBD Cereal and Puffs. Give me just a second. Okay. You have CBD Cereal and Puffs, and these are real. I swear to God. There's a website that sells some of these. Captain Crunchy Munch Berries CBD Breakfast Cereal. That's apparently a real thing, as is Weedo's CBD Puffs. But where it really starts getting interesting is there's apparently CBD-infused workout gear as well as CBD-infused bed sheets. Now, I'm not real sure how they work, but I'm definitely curious, and I may have to get some just to check it out. One other reason why I think CBD is so hot right now is that it's really penetrated middle America. And what I mean by that is, and let me give you an example. So I'm originally from rural West Tennessee, which may be shocking to some of you given my lack of accent. But I went back there for Christmas, and I was talking with my mother who lives there, and she was talking about how all of her friends are using CBD products and how it's fantastic and it's really helping them. And she was talking about how she bought CBD stock and how there's even a new little CBD store in this really, really, really small Tennessee town. So I know that's anecdotal, but it really, I think, demonstrates how widely accepted CBD is in a way that marijuana and other cannabis products are not. And so I think that's something else that is fueling the growth. As is what I just mentioned, that CBD is hot because it's seen as a cure-all, and there's lots of things out there where the health benefits of CBD oil are being advertised for a lot of these products, and we're going to talk about some of those as we go through this. So that's sort of a quick little synopsis about CBD and intro to it. I will say that there are storm clouds on the horizon, and that's what we're going to talk about in the second half of this presentation. But for now, I will turn it over to Royce and Kate so they can give you a little bit more about the basics of CBD.
And just advancing the slide here. Yeah, so I'm Royce. I work out of Chicago office. I focus mostly on FDA regulatory issues as well as USDA regulatory issues. So what is cannabis is always the question I get. How is CBD different from cannabis? So the cannabis sativa L plant, which is the most commonly grown one, contains CBD, which is cannabidiol, as well as THC, which is the psychoactive component. CBD acts on the endocannabinoid system. THC gets you high. So marijuana, which is, has above 0.3% THC, which excludes it from the definition of hemp, is currently a Schedule I drug with FDA, or DEA has scheduled it as one. FDA has said there's no useful component or medical part of it, so it's an unapproved drug. And in Schedule I, it exists with its friends, peyote, LSD, and heroin. And so CBD is different, though. Although CBD is derived from the cannabis sativa L plant, most of the CBD out there right now is extract from the plant, and it comes from a plant that has 0.3% or lower THC content on a dry net basis. And that's important because that means that plant under the 2018 Farm Bill would be classified as hemp, which is legal to grow, provided the state program has been approved by USDA or it is grown under a state research program. So a lot of the CBD out there has really low THC content, or it should, and it's possible, though, that it could be marijuana plants in states where there are approved marijuana grows and it just happens to have a low THC content, but to really get that federally protected status, it needs to come from a hemp plant. Medical marijuana is still out there. That's not CBD. That's still full THC. That is a cannabis plant that has been grown for the specific purpose of being medical marijuana under a state's medical marijuana grow program. Next slide. Kate, I think.
Yep. Thanks, Royce. I will pick it up. This is Kate Hardy. So Royce just went over the difference between CBD and medical marijuana, and as you all probably know, there's all these terms kind of get thrown around. So this slide is to try to put the picture together a little bit more and show you the difference or really similarities between hemp versus marijuana versus CBD. The key to this is all of this comes from the same species of plant, the Cannabis stevia, so it's very similar. The other thing to point out here is that both hemp and marijuana are regulated by multiple different agencies and in many cases overlapping agencies. So the other question is, okay, that's hemp, that's marijuana, where is CBD? Where does the CBD come from? And CBD is just really an extract from these plants that gets pulled out. So when we're talking about CBD products, really what this slide wants to show you is kind of where do these issues come up? Like, what is the problem? How does all this start from a regulatory perspective? So just to give you a high-level overview, the Food, Drug, and Cosmetic Act prohibits the introduction or delivery into interstate commerce any food, which includes an animal food, where you have added a substance which is an active ingredient in a drug product that's been approved under the Food, Drug, and Cosmetic Act. And right now, as you all probably know, there's several products out on the market. The most recent one approved by FDA that has CBD is Epidiolex. And we'll talk about this more later. There are certain hemp seed ingredients that FDA believes is fine to legally market in human food. But a key takeaway here, and to remember as we talk about these issues as it comes up, is any substance that's intentionally added to a food is a food additive and subject to pre-market review and approval by FDA. And Royce, I'll turn it back to you to talk about the dietary supplements and a little bit more on the food aspect of these products.
Thanks, Kate. So a lot of CBD products have been out there right now trying to label themselves as dietary supplements or portray themselves as dietary supplements. And dietary supplements, as you all probably know, is a unique category under the Federal Food, Drug, and Cosmetics Act. It came about from DSHEA, the Dietary Supplement Health Education Act of 1994, which said, dietary supplements are, they're kind of food, but they're its own unique category. And in order to be a dietary supplement, your product was either grandfathered in at the time DSHEA came out, or you gave notice of a new dietary ingredient to FDA through a notification process. And your ingredient was shown to be generally recognized as safe, or FDA had come to the conclusion that it was grass. The benefits you get by being a dietary supplement is you get the protections of DSHEA, which means that you can make structure function claims if you give notice to FDA. So what's a structure function claim? It could be, helps the body naturally heal, or brings about calm in the body, kind of amorphous general claims about how this product could globally help you. You can't say under DSHEA, if you're a dietary supplement, you can't make a disease claim. And that's only allowed for drugs with approved indications. So sometimes we see CBD products out there saying, cures cancer, prevents memory loss, defies aging. Those are all claims that kind of slip into the world of a disease claim, which is where we've seen talk about it later, but the bulk of FDA enforcement. And, as a rule, all food consumed must be generally recognized as safe, meaning that it's been subject to a GRAS notification or it's been grandfathered as GRAS. CBD has never been subject to that. And that's one of the problems out there with it, is that it doesn't have a GRAS notification, and it never gave a new dietary ingredient notification. So one of the other areas that we've seen CBD in is kind of separating apart our cosmetics. Cosmetics are a category under the Food, Drug, and Cosmetics Act that are, basically meant to, be either skin, beautification creams or makeup or lipstick. And cosmetics have a couple of rules attached to them, that there can't be any prohibited chemicals in them, and FDA gives a list of that. And it can't be misbranded, and it can't make disease claims. But we see CBD being added into these products, and some of the more conservative products won't have any of the disease or structure function claims attached to them, but some of the more aggressive products will market the CBD as being in the product as having some sort of therapeutic quality, and that's kind of the trigger point or the line that gets crossed where we start seeing more and more FDA enforcement the further you go down saying that your cosmetic can do something. And, as Kate alluded to earlier, CBD versus hemp in food products. So in 2018, FDA recognized that people were consuming hemp, and that people were consuming it in seed form, powdered form, or in oil form. And FDA said, okay, that's grass. Those are safe. If you want to have these sorts of products that have hemp, that's going to be okay, and we're going to allow that in food. So it could be something like a hemp seed granola bar, or we've seen hemp in, added to cooking oils and things like that. And those are generally recognized as safe. Where it gets tricky, though, is when you start marketing on the CBD. If you start marketing on the CBD, if you start going away from just being the pure parts of the hemp plant, you're starting to cross the line from where it was grass under FDA, where FDA did say, okay, that this part of the hemp plant is okay, it's good, it's a hemp seed, to now you're marketing on the extract. And the term hemp extract actually has a defined definition within the 2018 Farm Bill, and it includes cannabinoids. So when you start marketing on the CBD or the cannabinoids, you're starting to go further away from the grass notice area where you're safe. And you're starting to get more into the risk area of marketing on the CBD, which has no grass status, which has no benefit that FDA has seen, and is an adulterant if added to food under the FDA's eyes.
Hey, Royce, this is Trent. Let me ask you a quick question about that. One of the things that I've seen and sort of heard is that there are at least some companies in the CBD space that are considering changing their marketing a little bit, and instead of saying, oh, look at our CBD infused whatever, they're looking to maybe use the term hemp extract, which is what you just mentioned. It sounds like that maybe is a safer term to use, but I guess maybe you don't get the benefit of the CBD marketing. But I just want to ask you that question. Is that in fact the case, that using hemp extract instead of CBD puts you in a safer place?
Yeah, no, absolutely. I caveat everything with, as of today, January 16th, this is my opinion because it changes constantly. I think that as you move more towards hemp, as you start trying to market your product as hemp, and it gets a little bit more difficult and ambiguous for FDA to say you're marketing on the CBD. I don't know if it's a complete protection from it, because FDA is going to look at other factors about, what are the claims around the product? Is this product mostly CBD, but it's just that you're disguising the term with hemp? Because some of the things that we've seen, and we'll show a slide later, is you're calling it hemp extract, but yet you're marketing on the CBD. Product contains 40 milligrams of CBD, which is probably a higher concentration than just the seeds or the parts of the hemp plant that you would get in your morning granola. And that's kind of where the line is as you start to shift more to marketing on the CBD. And you can say something's hemp, but what does that do for your business? How does that sell your product if the real reason people want it is for the CBD? And, there's levels of enforcement risk in all of this. You may be able to call the product CBD, but make some claims, not others. And I think in general it is still gray, and it depends on a multitude of factors to consider, and that's why labeling and reviewing the labeling is so critical and important here.
Thanks, Royce. This is Kate. That's actually, that's a great segue into the next slide, where we're going to touch briefly on FDA enforcement of these products. And in fact, FDA has been looking at these products and sending warning letters out for a couple of years now, all the way back to 2015. We've got a list of warning letters on the right of this slide, which we'll see has grown exponentially on the next slide. But one key point here as well is FDA several years ago started testing some of these products to see how much CBD is actually in them. Is it exactly what's been claimed? Is there any THC in these products or other derivatives from the plant? And what do they look like? And you can see here that there is a wide variety of what actually is in the product once it's tested. And from an FDA perspective, right now their biggest concern, and one of the things that's made it so difficult to just quickly regulate these products, is that one, there's no standard at this point really for the amount of CBD that should be in a product, and two, there's not a lot of history and data as to how these products just interact with the body in general. The approved product, Epidiolex, has very clear liver warnings, so that is a concern. There's also no real data right now as to how these products interact with any other medications that people might be taking. So that is a definite health concern, and one of the reasons why it's just very difficult to quickly move to regulate these products. And on the next slide, you'll see here, again, the list of warning letters in 2019. You see on the left, it's just grown substantially. And on the right, I'm not going to spend too much time on this, but because we will talk about some of this later with the cases, FDA does have on its website several FAQs answering a lot of questions with respect to THC or CBD in products such as dietary supplements, such as animal food. It also talks about its regulatory and enforcement posture at this time. And you can see from some of these questions with respect to CBD as a dietary supplement, FDA's answer is no. CBD in animal food or feed, the answer to that is also no. And then this last bullet down here, FDA has indicated that, yes, they have sent letters to many companies. The primary focus is similar to what Royce alluded to, are those products that are making claims with respect to treating diseases, curing cancer, sort of making what's much more similar to a drug product claim. Also, if you're claiming that your product is a dietary supplement, that may put it higher on the radar screen. And so that is just a very quick and high-level overview of some of the regulatory issues that are presented in these products and the agency perspective with respect to these products on the market. So now we will move into talking more in detail about the class action lawsuits that have now started to be filed.
All right, thanks a lot, Kate. And I think that's a really great overview that y'all gave of things. So let's talk about the litigation behind this. So here's the storm cloud. I mentioned the storm cloud earlier. Here's the storm cloud. It's actually more of a wave. And it's not really that surprising that we're seeing it. I think that we all expected it, and we've been hearing rumblings for months and months that this was coming, and the dam really started to break, to mix metaphors, in the second half of 2019, with a number of these really filed in the last 3 months of 2019. And one thing I will tell you, I talked to one plaintiff's lawyer who is active in this area last year, and he said that almost all of his time, and this was, I want to say at least 6 months ago, all of his time was spent sending demand letters related to CBD. And so, the litigation obviously is out there. It's what's public, it's what we see, but there's a lot more. It's the tip of the iceberg. There's a lot more going on behind the scenes with CBD. And for every lawsuit that you see, there's probably, 5, 10, 20 demand letters that are out there that are CBD companies and those in this space are having to deal with. So there's a couple of additional things I wanted. First of all, let's get sort of an overview, the 30,000-foot view of where things are right now with the class actions. So there's roughly a dozen or so of these out there that we're aware of in federal court, at least. 6 were filed in California, and almost all of the ones in California were illegal to sell. So there's a couple of different categories, and in fact, actually, let me just show you the categories, the types of class actions we've seen. Illegal to sell, which Bethany's going to talk about in a few moments. Too little CBD, and then there's a different one where there's too much CBD/THC. And then there's some securities lawsuits. Those are the main categories we're seeing right now. And in California, almost all of them thus far have been illegal to sell. And 4 of the 5 of those illegal to sell were filed by the same group of 3 law firms. So they've obviously decided to file multiple lawsuits on that particular issue. And there's also a too little class action in California, but it's really Florida where we're seeing the too little class actions. There are 3 of those right now, and there are also cases in Maryland, Massachusetts, Illinois, Nevada, and Missouri. The one in Missouri is actually in state court. It had been in federal court, but was recently remanded back to state court. But the thing to understand about all of these cases is they're in the very early stages. So we're going to be obviously watching them very closely in 2020 to see where they go and how courts deal with them. One of the things that I will note is the 3 in Florida were actually filed in the Southern District of Florida, and those who litigate know that there's a number of judges there that can move very quickly. So I think there is a good chance that the first sort of results from these CBD class actions we're going to see in the Florida ones. We already have one sort of result that we're going to talk about here in a bit from one of those Florida cases. All right, so why are we seeing these class actions? Well, it's really the Wild West out there right now, and that may change very soon with some of the regulatory actions that may be taking place soon. But as of now, it's the Wild West. And we had sort of the gold rush analogy earlier, and this is what it leads to. There's a gold rush, and there's a lot of money at stake, and therefore the plaintiff's bar sees this and sees an opportunity because there's very, very little regulation and there's not a lot of certainty out there right now, and it's seen as sort of lawless. And this leads to gunfights and robbing of stagecoaches and that kind of thing, and that's what we're seeing with these lawsuits right now. Now, one of the things I wanted to note, and I think this is something that Royce and Kate touched on a little bit, but there was a number of warning letters that were sent in October and November by the FDA and FTC. The first one was sent, it was actually a joint letter from the FDA and FTC on October 10th to one particular entity called Rooted Apothecary, LLC, and it was basically saying that they were illegally selling unapproved CBD products that claimed to solve a number of health issues. And then on November 25th, the FDA sent letters to 15 companies in the CBD space saying that they violated or they're in violation of the FDCA. And it basically claimed that they were in violation because of dietary supplement labeling, unapproved new drug products, misbranded drug products, and unsubstantiated advertising claims, some of the things that Royce and Kate have already talked about. But one of the things I wanted to note is when we see these types of warning letters, especially if there's a lot sent out on one day to a number of companies, I mean, that's really significant. The plaintiff's bar sees that, and it really can spark a feeding frenzy. And one of the things that we did recently, we were trying to see how food labeling has changed over the past decade. And I think sometimes we forget that one of the things that spurred the food labeling class action feeding frenzy in the 2010s was the FDA jump-started the whole thing by sending a number of letters on one day in 2010. And shortly thereafter is when we saw the food labeling class actions really take off. So this is a really significant event, these warning letters, and something that we're obviously going to have to see what happens, but it's important to be aware of. There's also a lot of things out there, lots of advertisements looking for clients for new CBD class actions. This is from, I think it's classaction.org, that has all sorts of things on there where they're looking for new plaintiffs. And then the other thing that's probably driving this to a certain degree, and this is my last slide before I turn it over to Bethany to talk about some of the specific class actions. But, lots of times in the food labeling space, we may have products that are relatively inexpensive. Maybe it's a pack of crackers or a loaf of bread or something like that. Well, here with CBD, we're talking about some pretty expensive products, at least for some of them. And when you have really expensive products, and here's an example of one, I found this, it's $146 for this little, and it's not actually that, it's not some huge size, it's a really small size, 1 fluid ounce, 30 milliliters. And when you have something like that, it obviously, plaintiffs' lawyers' eyes light up when they see that, because that means there's potentially a very lucrative outcome for them, but there's also especially with some of the too little ones, if there's a claim that there's a price premium, it's going to be a much bigger price premium. I know that in a lot of the litigation we deal with, there's a price premium of 3 cents or 5 cents. Here, the price premium may be, $20, $50 or more. And you start doing the math on that, and it can really add up really, really quickly. So that's another reason why I think we're seeing these class actions. So with that, let me turn it over to Bethany now.
Thanks, Trent. I'm Bethany Lukic. I'm out here in our Los Angeles office, and I think it's appropriate that I talk a little bit about all of the action that's going on here in California with respect to CBD and, quite honestly, marijuana products as well. And obviously the focus of this webinar is CBD and not marijuana products. But, in California, you can find CBD virtually everywhere and anywhere. The grocery stores, drug stores are loaded with products. There are specialty shops popping up everywhere. You can have products delivered to your home. And so they're really everywhere. And because of the fact that California is so litigation-centric, it's not a surprise that a lot of these cases are being filed in California, although I will say it's interesting that a majority of these cases that Trent talked about that are being filed by this three group of plaintiffs firms, none of the plaintiffs firms on those pleadings are actually based in California. So I think that's interesting. There is one California lawyer on the pleadings, but the rest of the lawyers are from out of state, including Philadelphia, Tennessee, and Michigan. So I'm going to talk about the illegal to sell class actions, and in these class actions are really based off of, and I think will be even further fueled by the FDA's guidance materials that you can find on the FDA's website, and I included a link to sort of a main page on the FDA website in some of my slides. One of the FAQs that appear on the FDA's website that Kate and Royce alluded to earlier is that THC and CBD products cannot be sold as dietary supplements under the view of the FDA. And so as a result, the lawsuits are basically saying because the FDA say you can't market it as a dietary ingredient or in dietary supplement, if you do so, it is illegal and it's illegal to sell. The other FAQ that they're relying on is FAQ 10, which says that it is illegal in interstate commerce to sell food, including any food, animal food, or feed to which THC or CBD has been added, again, under the Food, Drug, and Cosmetic Act. The first case that I'm going to talk about is the DaSilva case, as Trent talked about, this gold rush, so that you can see sort of how rapid plaintiffs' firms are looking at what the FDA is doing and turning what the FDA is doing into lawsuits. You can see this with sort of any sort of warning letter that comes out by the FDA, but we see it across various different industries. So the minute you, for example, in the data privacy space, post something about a data breach, you see these follow-on, or register in a certain manner, you see all of these follow-on lawsuits. Same thing in the food industry. And you can see in this particular case, Infinite Product Company doing business as Infinite CBD got a warning letter on November 22nd. I think it took a couple of days for these to post on the FDA's website, but on November 27th, plaintiffs filed their lawsuit in the Central District of California. and the lawsuit really mimics the FDA's warning letter almost. It quotes it very heavily and mimics it almost to a T, and it lists about 10 different products. One of the things that we're seeing in these products, or in these cases, these illegal to sell cases, is that they're not very creative with their factual allegations. The factual allegations aren't, they're somewhat boilerplate in terms of they are quoting significant sections of the FDA's warning letters. And if you want to look at a comparison between a company that got a warning letter and what that complaint looks like and a company that didn't, you can compare the DaSilva case complaint with the McCarthy case, which I'm going to talk about in a little bit as well. So this case is in its infancy. The answer is due tomorrow, or the responsive pleadings are due tomorrow, so we don't know what the defenses will be for this particular defendant, and we are closely monitoring these. But as I said, the complaint itself really just tracks the allegations in the FDA's warning letters. This particular plaintiff bought a CBD isolate dropper, and he paid, I think it was about $40 for the product. So not one of these particularly high dollar products, but certainly more than a box of cereal or a carton of orange juice. The claims are being brought under sort of the normal series of consumer protection statutes out here in California, as well as various different warranty theories. And I'm just going to spend a little bit of time walking through those, because I think that this set of consumer protection statutes you'll see over and over and over again in these types of lawsuits. We saw them in the food, other food labeling context as well. Plaintiffs in these cases are suing under the California unfair competition law. Of course, that has three different types of allegations under it: unlawful, unfair, and fraudulent. The unlawful prong, they are saying that defendants' actions are illegal under the Federal Food and Drug and Cosmetic Act, as well as California's own Food and Drug Act, the Sherman Act, which basically anything that the FDA considers misbranding, plaintiffs typically then tack on this prong and allegations under the Sherman Act, because it gets them out of preemption arguments for the most part out here in California. They're also suing under California's false advertising laws, under California's Consumer Legal Remedies Act, the CLRA. They're suing under breach, and most of those, the UCL, FAL, and CLRA, they're suing for injunctive relief, and under the UCL, and after 30 days passes, because there's a 30-day obligation to give notice and an opportunity to cure before you can seek monetary damages under the CLRA, they're also looking for restitution. The breach of express warranty and implied warranty causes of action are basically based on the fact that the product has no benefit to the plaintiff, and then they're also seeking declaratory judgment. The California classes are for all of the California statutes. The only national class that they're seeking is for declaratory judgment. These same counts are continued in the second case that I want to talk about, the McCarthy case. Again, the same law firm. This one's pending up in the Northern District of California in front of Judge Freeman up there. Again, no responsive pleading has been entered, and in fact, it's not indicated that service has actually been made in this case, although there's a case management order set for March, late March. And in this case, they're seeking a nationwide class and a California class of purchasers of 4 different categories of products. And you can see here, I excerpted paragraph 17, which is their main allegation that says that all of defendants' products are misbranded as dietary supplements or contain the illegal dietary ingredient CBD. Every product contains a supplemental fact section on the back of the container, which is reserved for dietary supplements, and explicitly state dietary supplement on the front of the packaging. Unlike the Infinite case, the Charlotte Webb case, the McCarthy case is very thin on factual allegations, and that is because in this particular instance, there isn't a corollary warning letter from the FDA. And I think Kate and Royce will comment on this, but I think that FDA has really been focused on products that make claims that, there are curative factors associated with the CBD product versus just a straight, labeling issue in terms of this gray area of dietary supplements. And so then I'm going to move to what do we think, or what are we hearing that defendants might be arguing, or what are we seeing that they actually are arguing. One of the few cases that has a motion to dismiss out there is the Potter case, and so we looked at that. Some predict that defendants will argue that their product falls within the hemp exemption, that they're not marketing the product as CBD containing. And Royce and Kate already talked about sort of the hemp exceptions. And I pulled just a couple of products that I've seen in the marketplace out here. One is a recess product, and you can see it's marketed as sparkling water infused with hemp extract and adaptogens. I will say that when I was in the grocery store and came across this product, it was marketed to me by the salesperson as containing CBD and not necessarily hemp extract. Here's another product. This is one of the products that is subject to the McCarthy case, and you can see on the label it's marketed as a hemp extract infused gummies, but above that it talks about the 10 milligrams of plant-based cannabinoids per serving. So this is one of those sort of more borderline marketing labels that Royce was talking about. And it'll be interesting to see how the courts handle it and what the FDA eventually does about it, if anything. There are some other interesting arguments. Of course, one is preemption. Defendants are arguing, this is not for courts to decide without further guidance for the FDA. The FDA really needs to weigh in on this. All of these cases should be stayed pending that. And the other is kind of a unique argument that, the CBD in my product is not really the same CBD in the drug products that the FDA is regulating. My product has this very, very, very small amount of CBD in it, and so it should not be treated as the same. And that was one of the arguments that we saw in the Potter case. And so I think it's really going to be interesting and something to watch all of these cases, particularly out here in California, where pleading standards are a little bit more liberal and cases are allowed to proceed beyond motions to dismiss, and judges aren't necessarily always willing to stay cases. So it'll be interesting to see sort of how things proceed, and I'm going to turn it over to Trent to talk about Too Little and the other types of class actions we're seeing.
Thanks, Bethany. Really appreciate it. That's all very helpful. And I don't know, it's really hard to overstate how scary those illegal to sell class actions are, because it's essentially saying that if you have any CBD, then you're potentially vulnerable. Now, one other thing I wanted to note that I think has flown under the radar to a certain extent is a 11th Circuit case that came out back in November, and it wasn't in the CBD context, but it's called Defendants v. IQ Formulations, and it essentially held that if there is an alleged presence of an illegal ingredient, and this was in the dietary supplement space, then that renders the product worthless and it gives the plaintiff standing to sue. Now, for those of us who have been fighting in the food and beverage labeling litigation world for a number of years, that's an argument, the whole, this product is worthless because it's illegal, or there's an aspect of it that's illegal, that never really gained a whole lot of traction, especially out in California, which if it was going to gain traction anywhere is where you would think you would gain traction. But now we have a decision from the 11th Circuit out there, which is by no means, a liberal court, saying that it is in fact worthless, and that's a viable litigation theory. So that's something to watch, and I think it sort of intersects here with some of these illegal to sell class actions as well. We're going to talk now. Sorry, go
on that. Yeah, to sort of just echo that a little bit, it's one thing to get a warning letter from the FDA and have FDA involvement, but I think what Trent's emphasizing is where the cash really could, build and the numbers can get very high very quickly is in the plaintiff class action space. The plaintiffs aren't waiting for the FDA necessarily to opine on things. They're just filing suit out there. And if they're seeking full restitution prices based on a comment that it's worthless products, that those numbers can add up extremely quickly.
Yeah. Instead of talking about, 3-cent price premium or $5, you're talking about the whole $146 product. So you're exactly right, Bethany. All right, we're running a little short time, so we're going to move quickly through Too Little CBD. There are, as I mentioned, there's, I think, 3 of these lawsuits that have been filed in Florida and 1 in California. And they essentially claim that there have been a number, or that the products do not contain as much CBD or THC as they were led to believe by either the product label or some of the marketing materials. Now, what's sort of interesting about this, and we see this in the food and beverage space a lot, and a lot more now, is lab testing. So, you have these plaintiffs' attorneys that are going out and testing at labs exactly how much CBD is in there, and then they're comparing it. And I think that just goes, and that's one of the things I wanted to emphasize here, is that it's so important to realize and understand you will be lab tested. And whether it's CBD or food, it's going to happen. And you need to make absolutely certain that you know what is in your product, and you need to also be certain about, what is the consistency of the result, because it's still a problem if you have, 10 products that test one way, but then you have 3 others that occasionally test another way. So that's really important. And in cases, class actions involving lab tests are really hard to beat because there has been some bad law out there where courts have said, the plaintiff doesn't need to allege what the methodology of the lab test is. They don't need to even allege what the results were. They just put very generically in there what it was, and that is enough to get past the motion to dismiss. And I've been personally in situations where you get 6 months down the road or 9 months down the road in discovery, and you finally get the test results, and you find out they're using the completely wrong methodology, and their whole testing is completely off, and it never should have made it past the motion to dismiss. So, anyway, getting up on my soapbox a little bit there. The first case I want to show is the Snyder case, and this was filed in September, and it's the one where we actually have a decision thus far. It was a nationwide class for unjust enrichment with a Florida subclass for FDUPTA, which is the Deceptive Trade Practices Act in Florida. The court did not grant the motion to dismiss. It did narrow the case from some of the products. So they tried to bring in a lot of other products that were not purchased by the plaintiff, and the court said, no, you can't do that, at least here in the 11th Circuit. And so it narrowed the case based on that. And then the court stayed the case to wait on FDA guidance, saying it would benefit greatly from it. And it said that the rulemaking processes at the federal level is active, and given that it's in the nature of public interest litigation, I'm going to wait on that. And the court also rejected the defendant's argument that, well, they could have found out the info on the amount of CBD through a scannable QR code or website. So we'll want to watch this very closely, but it's the first sort of hint of how courts may deal with this. The next one that we have is the Potter case, which Bethany mentioned, and it also had a national and Florida class alleged. We do have a motion to dismiss from plaintiffs, and they have a number of arguments, as you might expect. They argue no standing. They argue primary jurisdiction, that it too should be stayed. They allege that there was no concrete injury, but they also allege that, you know, we have the federal regs give us some leeway for the actual amounts of natural nutrients in dietary ingredients, that there's a FDCA 80% safe harbor. So in some ways, it seems like they're maybe acknowledging that maybe not all of their product had as much CBD as they originally advertised. So we don't have a decision on that. We don't know how it's going to shake out, but this will also be one to watch. And now I'm going to turn it over to Jenny to talk quickly about a couple of other ones.
Sure. Thanks, Trent. So Gaddis is the next case, also in the Southern District of Florida. This was filed in August of 2019. Another case where plaintiff is claiming that the product overstated its CBD content, another nationwide class action. The complaint alleged that the lab test only had half of the CBD that was advertised. The plaintiff had bought CBD apple gummies in a honey liquid tincture, but essentially brought the lawsuit on behalf of all 50 products that Just Brands sells, which mirrors some of the approaches that plaintiffs' attorneys have taken in some other food labeling cases. So this case had an amended complaint that was filed in December. Defendants responded again with another motion to dismiss and also a motion to stay discovery. So we'll keep an eye on this, but again, all of these cases are just in their infancy. The next case is actually the California case, which is the Too Little CBD, which is the fourth Too Little CBD class action. This one, again, filed in California, filed in December of 2019. This one involves CBD-infused chocolates, and saying that the amounts of the THC or the CBD are not what was reported in the marketing and on the product labeling. The methodology and the exact results from the plaintiff's lab tests were not revealed in the complaint. And again, this is another proposed class action that we're watching closely, but again is very early on in the litigation phase.
All right, thanks, Jenny. We're just going to mention real quickly the last two categories. I think that the categories we have touched on and talked about are really the main two right now. There are two other categories. One is too much CBD, and we mentioned one of them here. And there's another one as well, the Ellis case that had been in Missouri, Western District of Missouri. It was removed there. It was recently remanded back to state court. Both of those cases claim that they were fired or rejected from a trucking job after failing a drug test after eating the product, saying that they were not aware that there was actual active THC in those labels. So very interesting lawsuits there, and class actions there as well. So we'll want to watch that closely in addition to other ones. And then there's a securities class action, and we're not securities lawyers, but we did want to flag this to say that there have been a couple of lawsuits related to securities and CBD.
Right. Just really quickly, those two cases were about companies that were trying to get investors to invest in their CBD products. One was supposed to be an energy drink called Nitro G, and they were going to manufacture that in Malaysia, but growing marijuana plants in Malaysia is illegal, and so once that was discovered, the stocks apparently plummeted and the investors lost a bunch of money. And then the next one is about, again, stocks plummeting with a CBD smokeless tobacco product that had been presented to investors as patent pending, but the patent had actually been rejected twice. So.
And I think what we wanted to do here real quickly, and we're only going to take another 2 or 3 minutes, but what are our predictions on where things are headed? And I'm going to ask each of our panelists to weigh in with maybe 15 or 20 seconds, one quick prediction. Mine is, this is a very real threat. These class action lawsuits are very real. There's going to be a lot more of these lawsuits. They do have legs. I think a lot of them will get past the motion to dismiss stage and will go to the class certification stage, and we're going to start seeing settlements for some of these in 2020. And remember, these are 1.0. I mean, they are going to evolve. They are going to get more sophisticated over time. So that's mine. Jenny, do you want to, anything you want to add on that?
Sure. I mean, I think that Trent's exactly right, that we're going to see more and more of these, and it's going to be interesting to see how things play out with a lot of the smaller companies that are investing and putting CBD products out there, and how it's handled, both with the two sides of, I guess, the two bookends with the FDA and rulemaking process along with the courts, and whether it's going to create some sort of patchwork that we're going to have to rip apart and try and make whole in some way. It'll be interesting to see how that plays out through the court process as well as the FDA.
How about you, Bethany?
I guess my advice is to don't be a lemming. Just because everybody else is doing it doesn't mean you're going to get a free pass. And so I think, keep a close eye out there and don't try to try and be too cute. You might escape the FDA right now, but you may not escape. If you're successful, you're not going to necessarily be escaping plaintiff's counsel. Pay attention to the press out there, and there are various different trade groups and even lawyer groups. So, for example, the LA County Bar Association has its own cannabis and CBD group or committee. So pay attention to what's going on in those committees and call Kate and Royce for labeling advice.
Yeah, exactly. Kate and Royce, anything else you want to add?
This is Kate. I'll just jump in really quickly.
Yeah.
Oh, yeah, I'll just echo everything that was said. I mean, in particular, the more you can do on the front end to really analyze the product and the claims that are being put out there and the labeling, it's very important. And just as with the class action suits, we're keeping a very close eye on what FDA is doing and also what Congress is trying to do to push FDA along to hopefully get some better clarity in this area.
Yeah, and I don't think, this is Royce, I don't think we're going to see FDA come down with any sort of like golden guidance on CBD, at least in the next couple months or maybe the next year. The way FDA is going to enforce is through, warning letters, 483s, and that's really where the agency, I think, is going to show its true colors on its policy on CBD. I don't think the policy is going to be in a guidance anytime soon, but we're going to have to read the warning letters and read, any 483s that do become publicly available. But in this area, you also have to always be aware of FTC as well. Look at the FTC risk if it is separate from FDA. They've been enforcing jointly, but FTC will show its position as well through its enforcement.
Yeah, and I guess this is Kate. Sorry, I know we're running over. The one other thing I think will be interesting to see is we have all these warning letters out there. FDA does have the power and authority to get these products off the shelves and out of the market if they want to take that next step. We'll have to see if they decide to show their enforcement muscle a little bit more and go beyond the warning letters and go back to some of these companies and say, not comfortable that this is fixed, your product is now coming off the market.
Yeah, that's exactly right. And then the last slide here, we're not going to go through it just because I know that we've already mentioned a lot of these. There's a lot we don't know because this is still in its infancy. But the things I think that are most important to do to try to avoid litigation is, as Bethany and Kate and all of us have really mentioned, is stay on top of this. Keep your finger on the pulse of what's going on with the FDA and with this class action litigation, and just make sure that there's nothing on your labels or health claims or whatever that's going to make you more vulnerable than you already are, or that could result in lawsuits. So anyway, thank you everyone for attending today. I know that there were some questions that we did not have a chance to get to. We will get back to you with those questions, and as always, if you have other questions that you wake up in the middle of the night and you're like, oh, I wish I'd asked that question, feel free to give us a call or email us. Thank you so much for attending today.
Thank you.
Corey, I think we're ready to go out of the live stream.